about the DPO. So the Decree 13, they require the company to have at least one person to in charge of the data privacy.
However small they
and
are, like small
or
company
a
also have,
department. Sorry,
a small company also have to have a DPO.
it's not the small or big. It depends on the act. If your company had the processing activity, and then yeah.
Okay.
Yeah, and then in this slide, the DPO actually in Decree 13 there is no clear guidance on the qualification of the DPO. But from my experience, I think the personal data protection officer need to have like some capacity to manage and do the application notification to the department, authority department, and also can clarify, explain to the cybersecurity department when there is the investigation. So I pause here and ask Mr. David that in Malaysia, do you have any like qualification for the DPO? I mean the specific requirement for being a DPO.
It's not the law doesn't mandate that the DPO should be qualified in any area or particulars or qualified in personal data protection, for example. It doesn't. But generally, the data protection officers tend to be legally qualified or from the legal department of the company. I think more in Vietnam, I think that's even more required, if I may put it that way, whether or not a company needs to get a legal person in, if it does not have a legal department, to be the protection, the DPO, or whether a company needs to sort of hire a law firm and to have a designated lawyer as the DPO, if that's possible. Because if you look at your Article 23, the things that a DPO needs to do, I don't see how it's done by any ordinary person. You are responsible for the description of consequences and damage that might occur. You are responsible for the description of measures for handling and minimizing the harm caused by the violation. And this seems to be deeper than just hi, there's been a breach, or hello, there's been a breach. Okay. You know, it goes deeper and there's more information that needs to be given. So in fact, it may even need to be two people, like DPOs. One, like, so from a legal perspective, the other one maybe from a IT perspective, for the IT impact, right, of the damage impact. So it might need to be it may not need to be one person.
Yeah. So I agree with you, David, that yeah, when there's one client, they ask me how to appoint or assign DPO, because now the Decree 13 is took effect, and then they need to like appoint a DPO, right? And my advice is they may like use the current employee, current staff, like the legal counsel, in-house counsel of the company, to come the position of DPO. And also, beside one DPO as a contact person, then there will be a group department to build a department in charge of the data privacy. So that group will include the legal counsel, the IT department, like you said, the compliance department, yeah, and it came to a group. That's my advice to the client. Yes. This is the also like Mid-Diep said in the first session about the regulation, the internal regulation. that when the decree 13 is effective, we need to review our SOP, the standard operating procedure and regulation to check if the regulation they follow the decree 13 or not. For example, the internal labor rules when they want to like whether there is the violation of personal data is added at an act which may be discipline. If not, company need to amend the ILR or the non-disclosure agreement. We also need to review if there is the content of the uh, personal data or not.
Can you give me the example how the internal labor rules can violate the personal data? Can give me example how internal labor rules can violate the personal data protection?
No, the internal labor rule will not violate, but I mean here is that the uh,
Put
let's
the
say about the
protection.
the employee, because when you want to discipline
Yes,
the employee,
right.
the act must be added in the ILR.
Oh.
Yeah. So if the act, for example, the violation of the data privacy is not put in the ILR, then there's no basic for the employer to do the discipline.
Okay. Yep. Thank you.
Yeah, here is the procedure to submit the impact assessment report to the authority. As I know now that there are two ways. First is the company can access the National Information Portal on personal data protection to submit the dossier, or they may submit the dossier directly to the cybersecurity department. But for the information portal, it doesn't active yet. So you may use the second way that you need to submit directly to the department. And for the impact assessment reports, you will need to download Form 04. You fill the information in Form 04 and send this Form 04 with a text document to the cybersecurity department within 60 days from the day of data processing. And the authority will review and feedback within 10 working days.
But my question is, what if I don't do all of this? What would be the sanction if I don't fill in the form?
Yeah.
And I mean, not 60 days from the day of data processing. Who knows that what is the date of my data processing? I process data every day. I don't even don't remember what I did process, and that would be a cumbersome for me to every time I process any data, because I'm talking about terabytes. I have to fill in the form and submit to A05. A05 will review feedback within 10 working days. I don't even know what they're gonna do with my data, because A05 is the police. I don't want to share my personal data to the police as well, if that's private, and there's no public interest on it.
Yeah, that you can say before the decree 13 is effective, but now the decree is effective already, then you need to follow. Although now there is no
who follow that so far. How many people follow that?
I don't know, but now the company need to follow, or the company need to follow if they have the data processing activity. Yes.
And if they don't?
Like I said, there's no regulation yet on the administrative sanction, but I think soon there will be. Yes. And besides, if there is the violation and the data subject, I mean the data owner may sue you at a civil case.
Of course.
Yeah, to ask for compensation. Yes.
But why should I get the government or the police involved on that? I have to protect the data for the data owner, but not to send that to the police. That's another issue.
Yeah. Okay.
Yeah.
And move on. I would like to share the procedure of the transfer personal data abroad. actually the procedure is the same as the assessment report of personal data processing. It also need to fill, but the form is form 06, and you submit to the 05. A 05 will review and feedback within 10 working days. Yeah.
But
And
when
the
you say
result
this-
will be on the national information portal, or the result will send to the company address.
Yes, but when you say send files, what kind of files? You mean send the data or send the form on?
Yeah, your question is here. These are the document you need to prepare when you submit.
Good.
Like form no 46. The second is the personal data processing impact assessment document. It is regulated under Article 24 and 25 of Decree 13. The
Yeah.
third is the enterprise certificate.
Okay.
The fourth is the decision to assign the DPO or the
Okay.
department. The fifth is the contract or the agreement between the company with other party. Let's say the company is the data controller, and the company hire other party to do the processing.
Yeah.
And then you need to provide the contract between you and the data processing party and other document. So I think you can refer my slide when you are at home. But I just to sum up, I think now we are in the we need to follow Decree 13, because this is the one not too new for other country. So the reason why Vietnam issue Decree 13 is to harmonize our law with the world. And it also benefits for the company in Vietnam, because when there is the data the processing, then the other law of other country may say that if Vietnam has the law on data privacy or not. Yeah. So if the Decree 13 take effect, right, then we can say that we have, yeah, and that's bad for the harmonization between the law of Vietnam with other country. That's the thing. Other thing is the impact assessment. You can see on the slide. Yeah. Thank you.
Thank you. Very interesting. Now for Q&A, please.
Just in respect to the DPO, I had a question. For example, if there is an international company that has a subsidiary in Vietnam, can the DPO be in the parent company outside of Vietnam, or does the DPO has to be in Vietnam?
Yes. Okay. Your question is very it's a very hard to answer, because like I said, there is no qualification or requirement under the law to be the DPO, right? So, but the principle is that the DPO need to is the contact person. So that's the main thing. If the DPO is, let's say, in another country, and when there is the case in Vietnam, and how that DPO can handle, that's the thing. The authority may say that, yeah, I don't care where the DPO or who is the DPO, but when there is the case, there must be a prompt action from the company. I mean the DPO. So yeah, that's my answer.
Thank you.
Yep. Other question? It's okay. Yeah.
Just a note for those who join online. If you have any questions, you can type on the chat box, and then we will answer.
Yep. Thank you. So other questions in relation to Vietnam or Malaysia? But thank you very much, David. It's a wonderful presentation. Also, hi.
Thank you. Thank you much.
That we now that there's a big regulations coming in,